And in this talk today, I'm just going to be giving you some very basic information that might be helpful to have if you're thinking about making a will. So a lot of people find the prospect of making a will off-putting for, I suppose, a number of reasons, really. At a more basic level, people find it a bit morbid to be thinking about what's going to happen after they die. Also, people might be worried about the expense of engaging a solicitor, or even, what they're going to discover at that first appointment with a solicitor, where you give your solicitor instructions to make a will. So actually, at that first meeting with a solicitor, where your solicitor takes instructions from you, you have to absorb as a client an awful lot of information about succession law. And it's not, it wouldn't be surprising for someone to be quite overwhelmed by all that information, and also maybe a little bit confused about it. So the aim of this talk really, I suppose, is to take the mystery out of will making, and also to outline the limits on your testamentary freedom. Okay, so what we're talking about there is that there are certain legal protections for close family members which kick in if they feel like they have been disinherited. So we'll talk about those protections as well. So the idea is really that you'd be more familiar with very basic rules before you go to see your solicitor. So I suppose the first thing to talk about is, hold on now, what happens if you don't make a will? So if you don't make a will, you're said to have died intestate, okay? And if you die intestate, there's a piece of law, the Succession Act 1965, which sets out the order of entitlement, which identifies who your intestate successors are, okay? And basically, they will be your nearest next of kin. So if you die and you're survived by a spouse, but you've no children, your spouse will be your intestate successor. They'll take your entire estate, all your property that you own when you die. If you die leaving a spouse and children, then 2/3 of your estate will go to your spouse, and 1/3 is divided equally between your children. Okay, if you die and your spouse is no longer living, then your children will inherit if you have some, and the estate will be divided equally between them. If you die and you don't have a spouse or children, but you're survived by your parents, then one or both of your parents will take your estate. And if you don't have parents living, your estate will go to your brothers or sisters. And after that, if you don't have brothers or sisters, it'll go to your nieces and nephews. And then after that, basically your estate goes to your closest next of kin, as identified by a formula that's set out in the Succession Act, which you wouldn't really need to be aware of. But basically, the law can identify which of your relatives are your closest next of kin. It could be your grandparents, it could be a first cousin, it could be a second cousin. And if it isn't possible to identify any next of kin, then the property won't remain ownerless. Okay, it'll go to the state, because the state is deemed to be the ultimate intestate successor. So that's what happens if you don't make a will. You die intestate, and your intestate successors will take your estate. I just thought it might be helpful to put up the format of a very simplistic will, just so you can see what it looks like, and we'll identify the various parts. So the first sentence there is just really an introduction. This will is made on the 1st of February 2012 by me, Joe Murphy, of 11 Milford Grange, Castletroy, Limerick. So Joe Murphy is the testator here. Okay, so the testator is the person who's making the will. The next sentence there is called a revocation clause. I hereby revoke all former wills and testamentary dispositions made by me. Okay, so if he's made a will before, then it's revoked and it's replaced by this will. The next sentence is very important. You have to appoint executors, and they are people who will administer or manage your estate. Okay, so usually people appoint 2 executors, and they're also known as personal representatives. Okay, so he's appointed Liam Murray and Tom O'Sullivan to be his executors. Now, the executors basically have to, they'll usually go to a solicitor and engage a solicitor to carry out the work on their behalf, and they'll administer the estate. So basically the solicitor will apply for a grant of probate to give them authority to act. And then the solicitor will fill in all the paperwork on behalf of the executors and administer the estate. So really it ends up being the solicitor who does all the work on behalf of the executors. So a probate solicitor will do that work. So their jobs include paying any debts or expenses that are owing, and collecting in any assets. Okay, so, collecting in money from bank accounts, for example, and preserving any assets that may be necessary to take out insurance, for example, and then finally distributing the estate. So you distribute the estate in accordance with the will or the rules governing intestacies if there was no will. So following that, we have the legacies. So if it's a legacy of land or buildings, like the house here at 15 Milford Grange, it's known as a devise. Okay, so that's just a technical term for it, a technical term for a gift of land or buildings in a will. And if it's a gift of any other type of property, it's known as a bequest. Okay, so there was a bequest there of an antique dining table and some money. Then the last bequest there is an interesting one. That's known as a residuary clause. I give, devise and bequeath the rest, residue and remainder of my estate to my brother Ian Ryan. Okay, so a residuary clause is very important. Okay, all the rest of your estate goes to that person. If you neglect to include a residuary clause in your will, it means that you'll die partially intestate. Okay, the will be valid and distribute of the specific bequests that you've laid out, but the rest of your estate falls into an intestacy, so it goes to your next of kin. So that's what's known as a partial intestacy. So it's very important to include that residuary clause there. The final sentence then is an attestation clause, signed by the testator in the presence of us and signed by us in the presence of the testator. And that's where the testator signs and also his two witnesses. We'll see later that there are certain formalities have to be complied with in order to make a valid will. The will has to be properly witnessed. Okay, so that's the basic format of a will. So I've mentioned already there might be a partial intestacy if you don't include that residuary clause. Okay, so you could have the will distributing of some of your property, and then some of your property could go on intestacy to your next of kin if you didn't include that residuary clause, for example. Another couple of just basic points about wills is that the first one is that a will is revocable until your death. Okay, so even if you say this is my last will and testament, that doesn't hold any weight in a court of law. You can revoke a will up until you die. Okay, and typically you'll revoke a will by making a new will and including a revocation clause revoking former wills. A will is also revoked though if you enter into a marriage after you've made the will, unless you made that will in contemplation of the marriage. Maybe you were engaged when you made it. So a will is revocable until your death. You could revoke a will as well. Usually it's by just making a new will, but you could also revoke a will by destroying it, so long as you had the intention to revoke it. Okay, so if you destroy a will with the intention of revoking it, that would act as a revocation. So one thing you might be interested in is whether you need to necessarily employ a solicitor to draft a will. And you don't. I mean, there are homemade wills and, but I suppose, you just have to be very careful. And there are certain advantages to employing a solicitor. I suppose a solicitor will make sure that your will is valid, okay? And they'll make sure each gift is valid, okay? So if you make a homemade will, there's a chance that it could be deemed invalid afterwards, okay? So you're running that risk. So you'd have to be very, very careful about it. So the other thing is that a solicitor will be in a position to give you advice on the succession rights of your surviving spouse or children, okay? What protections are there for them if you want to disinherit them? They'll also be able to advise on things whether a trust is necessary. If you have minor children, for example, they'll recommend setting up a trust for them. Or maybe you have a child with a disability, for example, it might be necessary to set up a trust as well to look after them. And they'll also be able to give you some tax advice. I suppose, to be a bit cynical about it, if the will is deemed invalid, or if any of the gifts in the will are deemed invalid, the potential beneficiaries, the beneficiaries who would have benefited from the will, can sue the solicitor for damages if they don't get their benefit as a result of that solicitor's negligence. So if the solicitor is negligent, you have a mark. The potential beneficiaries have a mark there. They can sue and get damages. So they're the reasons why you would employ a solicitor to draft a will. So I suppose it's better to be safe than sorry, and it's a lot of money for it's dealing with your estate. There could be a lot of money involved. It could be a large estate, so it is typically recommended that you would employ a solicitor. Just then, to make a valid will, I suppose there's two steps. The first one is that the testator has to have what's known as testamentary capacity, okay, the capacity to make a will. And then the second step is that certain formalities have to be complied with to make a valid will. So we'll just look at testamentary capacity first of all. And the rules in this regard are set out in Section 77 of the Succession Act 1965. So the first rule is that you have to be 18 years or older to make a will. Okay, there's no upper age limit. Then you can make a will at the age of 100 if you want to. But I suppose just to bear in mind that the second requirement set out in Section 77 is that you have to be of sound disposing mind. Okay, now you may be slightly less than compos mentis in some areas, but you could still be of sound disposing mind. It's a legal test that was set out in a case called Banks versus Goodfellow. So you have to be of sound disposing mind. There's three requirements basically. You must understand that you're making a will. You must know the extent of your estate within reason. Okay, if it's a very large estate, you may not know the exact kind of specifics of your portfolio of shares, for example. And then finally, you must know who might expect to benefit from the will, and you must be able to decide whether or not to include them in the will. Okay, so often it's explained that you must be able to understand who might have a moral claim on you. Okay, now you don't have to give effect to that moral claim. You can leave them out of your will, but you must have considered them. Okay, or have considered their expectations. So that's the test for whether someone is of sound disposing mind. So you might look kind of like you're mad to the rest of the world, but you may still be of sound disposing mind. For example, in Banks versus Goodfellow, the testator believed he was being pursued by evil spirits, and he was still considered to be of sound disposing mind. So when might this be an issue? This could be an issue, for example, if someone is in a psychiatric hospital, okay, or maybe they're at the beginning of Alzheimer's, and that they're still okay, but that they're going to deteriorate further. And if those kind of circumstances exist, a solicitor will usually request that a doctor make what's known as an affidavit of testamentary capacity. So he'll get the doctor to kind of provide corroborating evidence of the fact that the person was of sound disposing mind. And also the solicitor in that case would take a very detailed note of what's going on in that interview with the client and how they found the client, just because the case could come up before the courts later on that the person wasn't of sound disposing mind. Who would challenge a will on that basis? Someone who's going to maybe benefit if the will is invalid, someone who's going to benefit under the rules which govern intestacies, for example, or someone who benefited under a former will. They might decide to challenge the will on the basis that the person wasn't of sound disposing mind. So they're the precautions that the solicitor will take. Basically, he'll get a doctor to swear an affidavit of testamentary capacity. and he'll take a very detailed note of the interview. So that's the first requirement. The testator must have testamentary capacity. Also then, the will itself must comply with certain formalities that are set out in Section 78 of the Succession Act 1965. So these set out, for example, that the will must be in writing. Okay, so it's not enough to make a video recording of a will, for example. It could be in writing, it could be handwritten, that would be fine. It could be printed on deed paper, very formal paper, or it could be written on the back of a cornflakes box. Okay, the requirement for writing is interpreted quite liberally. It must be signed by the testator or by some person in his presence and by his direction. And again, that requirement is interpreted quite liberally. You know, it could be just initials, and it'll be signed by someone by someone else by his direction if the person is unable to sign the will for some reason. Then the signature must be made in the presence of 2 or more witnesses. Okay, so the signature has to be properly witnessed. So each witness must attest by his signature the signature of the testator. So basically you would have 2 witnesses there while the testator is signing or acknowledging his signature. Okay, and they don't actually have to see the will itself. They just have to see or have been able to see the act of signing. One important rule in relation to witnesses: a person who witnesses the signing of the will or that witness's spouse cannot take a legacy under the will. Okay, so that whole rule it's set out in the Succession Act, and it's designed to prevent undue influence. Okay, someone coming in with a person into the solicitor's office and who's putting pressure on them to make a will and maybe leave them property in the will. So if they're a witness, they can't take a benefit under that will. Okay, so it's just a little bit of protection against undue influence. And then another rule set out in the Succession Act is that any alterations to a will must be executed. That just means signed and witnessed in the same way as the execution of the will. So often if you want to make an alteration, it's simpler to just make a new will. But if you don't, if you cross out maybe a figure for a bequest, you'd have to sign it and get it witnessed as well, that particular alteration, usually in the margin of the will. So the next thing I'm going to talk about are the limits on testamentary freedom. Okay, so you might think that you can do whatever you want in your will, that you can leave your entire estate to charity or to a new partner. And you can to a certain extent, but there are some protections there under the Succession Act for certain close family members. So there's an important protection there for your surviving spouse or your civil partner, and also there's an important protection there for children. Now, there are other people that are protected under different legislation that may be able to apply to court for provision out of your estate. For example, a former spouse, so if your ex-spouse who you've divorced now, they may be able to apply for a provision out of your estate, but the court would decide in its discretion whether to make provision for them or not. And also, since 2010, certain qualifying cohabitants may be able to apply for provision out of your estate as well. But it's you know, the qualifying criteria are quite stringent, so it's not everyone that's living with a person that would be able to access that kind of protection. So we're going to just begin by looking at the position of the surviving spouse or civil partner. So they have quite good protection under the Succession Act. Okay, they are entitled to what's known as a legal right share, and that's an automatic entitlement to a fixed share of the deceased estate. Okay, so if my husband dies and they've left me nothing in a will, okay, in their will, I can take what's known as my legal right share. So I can take half the estate if there are no children, But if he died leaving children, I'm entitled to 1/3 of the estate. So the size of your legal right share depends on whether there are children or not. Okay. So it's a half of the net estate. Okay, so the estate less any debts owing. Now, the personal representative, the executor, will inform me of my right to elect to take the legal right share instead of any gift under the will. Okay, he may have left me something small. He may have left me a stamp collection or something like that, and I can elect instead to take the legal right share. Now, just to mention another feature of the spouse's entitlement, you can exercise what's known as a right to appropriate the dwelling house under Section 56 of the Succession Act 1965. Okay, so if my husband died and he owned our home, okay, his name was on the title, so the dwelling formed part of his estate and I was ordinarily resident in it at the time that he died, I can use my legal right share, okay, whatever value that is of the estate, to appropriate the dwelling house. So that will usually give me the dwelling house. Now, typically nowadays, most married couples hold their family home as joint tenants in a kind of a co-ownership relationship known as a joint tenancy. Now, if that's the case, I won't need to exercise my right under Section 56 of the Succession Act. Okay, I won't need to appropriate the dwelling house because the house will become my own house under co-ownership rules. Okay, it's under a right of survivorship, it's known as. So if I own that house with my husband as joint tenants, when he dies, I become the sole owner under a co-ownership law. Okay, so I don't need to use succession law there to get the dwelling house. But if the house was in his sole name, okay, if my name wasn't on the title, Section 56 in that situation would be useful. Just to mention as well that the right to appropriate the dwelling house is restricted for certain types of dwellings. If it forms part of a business, or if, for example, it's a farmhouse, and in that situation you have to get court approval to appropriate the dwelling house, and the court will only grant its approval if it won't diminish the value of the other assets. What about if you're entitled to your legal right share, which is to the value of £200,000, but the house is worth £250,000? Okay, what about if the legal right share is less than the value of the home? Well, there's a couple of options in that situation. You can pay into the estate, okay? You can make up the difference. I could pay the €50,000 to make up the difference into the estate, and then I could appropriate the dwelling house. Or in case of circumstances of hardship, the court can waive the balance. That's what would happen in that particular situation. Just to mention as well, the legal right share can be renounced in writing. Okay, so if a couple got separated in a deed of separation, you would often renounce your legal right share, your succession rights to the other person's estate. Okay, so you can renounce your legal right share, and you lose it if you're guilty of desertion. If I had deserted my husband before he died, then I lose my entitlement to my legal right share. Also, certain people who are guilty of murder or manslaughter or attempted murder will lose their legal right share. Okay, and you would have heard about certain cases in the media where that happened. Okay, where someone couldn't benefit under succession law because they had murdered the person in question. So what about the surviving children then? There are also protections there for surviving children, but they're a different type of protection, okay? Surviving children don't have any automatic rights or entitlements to a share of the estate of their parents, okay? All they can do is make a court application to the court and demonstrate that the testator failed in their moral duty to make proper provision for them in accordance with their will. or otherwise, okay? And if they can demonstrate that, the court will make an order making provision out of the estate for the child, okay? They'll have to reduce certain other gifts and make provision for the child. So really it's quite different with the spouse. You have an automatic right to a fixed share of the deceased estate. With children, you have to make a court application. Okay, and the court may decide in its discretion whether or not to make provision for that particular child. Actually, often it's the threat of a Section 117 application will make a solicitor acting for the estate of the deceased settle the action. Because court proceedings are very expensive. So rather than run the risk of having to pay the costs of those court proceedings, it'll often lead to a settlement. So any child can make a Section 117 application. Okay, they'll have to prove, though, that there was a failure on the part of the testator to make proper provision for them. There are restrictions as well, in that an order under Section 117 cannot impact on either the legal right share of a surviving spouse, or if that spouse is a parent of the child in question, it can't impact on any gift to that parent. Okay, now that's an important limitation. Okay, so typically, the spouse will be a parent of the child in question, okay, unless it's a step parent. So if they're a parent, an actual parent of the child in question, and if, for example, the deceased left everything to their surviving spouse in the will, well, then there's no point in taking a Section 117 application, okay, because it can't impact on any gift to the parent. Who's a surviving spouse. So there's no point in bringing a Section 117 application in that situation. The child must make an application within 6 months of the extraction of the grant of probate. Okay, do you remember the executors extract a grant of probate to deal with the estate? So the child has to act fairly quickly. And unlike the situation with the surviving spouse, the executors don't have to tell children that they have this right to make a Section 117 application. Okay, so they may not be aware of their rights, and this time limit is applied quite strictly. Another restriction is that Section 117 is only available to children if the deceased dies leaving a will. Okay, if the deceased dies intestate, and he's survived by his children, then the estate is divided between the children equally. So sorry about that. There's a child just come into the room there. Charlie's barking. Okay. Will you close the door there? Okay. I'll clean it up in a minute. Sorry about that. Sick child at home today. So basically, it's not available on intestacy. In the case of an intestate death, the estate is divided equally between the children, and that may not always be a fair division. Okay, basically, one child may have looked after an elderly parent, for example, and may, I suppose, deserve more of the estate, but that may be the case, but they can't bring a Section 117 application. So if a Section 117 application is made by a child, the court will take into account a number of issues in deciding what provision, or whether to make provision for the child and what provision to make. So they'll take into account the size of the estate, okay, if there was a lot of property, the number of children, their ages, their financial position, the other moral obligations of the deceased person. Another thing that will be taken into account is the provision made during the lifetime of the testator for that child. Okay, so in one case, for example, there was the testator in question had sold a lot of shares and given each of her children about £250,000. And the child in question had squandered the money on a drug and alcohol problem, so they were kind of penniless by the time the mother died. So that child brought a Section 117 application, and the court said that, you know, the testator hadn't failed in her moral duty to make proper provision for the child. She had decided that more provision for that particular child wouldn't be in their best interests, and she had already made provision for the child during her lifetime. The court will also take into account the provision made for that child from other sources. Okay, so maybe they have a good job, maybe they have an inheritance from another source. So the court will take that into account as well. The court will take into account the relationship between the testator and the child in question. If there is a very bad relationship, for example, and if the testator treated that child very badly during their lifetime, well, then the court may be more inclined to make a Section 117 order if the testator didn't leave anything to the child in question. The court will also take into account any special needs on the part of the child. Okay, if the child has a disability, for example, and any other circumstances. So maybe, one child, as I said earlier, kind of cared for the parent in while they were dying, and they weren't left anything in the will. You know, those kind of circumstances would be taken into account by the court. And I suppose one thing I haven't said, but just to make it very clear to you, the court will consider applications by, independent children. Okay, they don't have to be dependent. Okay, they don't have to be minor children, for example. You could have an adult child bringing it, and usually do have an adult child bringing a Section 117 application, and that's fine. The Law Reform Commission is considering whether to change, has recommended really that the law be changed slightly in this regard, that there would be a presumption that adult children have already been properly provided for, but that change hasn't been introduced. So as it stands, an adult child can bring an application, and the court will consider the application from an objective point of view. Okay. Another issue that has kind of arisen before the courts is whether circumstances which occur after the date of death of the testator can be taken into account in a Section 117 application. And basically, they can't, okay, unless the court considered that there was a failure in moral duty at the date of death. Okay, so for example, if the testator had treated the child very badly and hadn't made provision for them, maybe didn't pay for their college education or give them a gift on marriage, if no provision had been made for them, and the court considers there was a failure in moral duty, the fact that the child has since been involved in a car accident and will need a lot of medical care, that could be taken into account in those circumstances. Okay, but if there was no failure in moral duty at the date of death, then circumstances after the date of death cannot be taken into account in the Section 117 application. So there's just a slight kind of distinction there. Okay, so that's kind of that's a run through all the law that I'm going to talk about. And it's I've tried to keep it very simple. But these are just a couple of recap questions just to kind of see if you have grasped the basics. So if Joe has been diagnosed with Alzheimer's disease, can he make a will? And the answer to that is that he can make a will, but he must be of sound disposing mind. Okay, and typically, and that's a legal test. Okay, he must be able to understand the nature of a will. He must understand the nature of the extent of his property, and he must understand who might have a moral claim on him. Okay, so that's the kind of tripartite test that's applied in deciding whether someone is of sound disposing mind. And usually what will happen in that situation is that the solicitor will ask the family doctor to make an affidavit of testamentary capacity, swearing that he has testamentary capacity. Okay, Nora then wants to draft a will at home without a solicitor. What would you advise? I suppose there's nothing to stop her, and handmade wills are admitted to probate. They also end up in court though. So you're running a risk that the will may not be valid, or that certain gifts may not be valid. Okay, so not everyone would know, for example, that you can't make a gift to a witness in a will. Okay, that gift would be invalid. So you have to be very careful if you do it without the help of a solicitor. And I suppose a solicitor can give you much more detailed advice about the will and its implications, and also advice about setting up trusts, etc. So the last question there is that Jim wants to leave all his property to charity and nothing to his wife and kids. Can he do this? Well, he can, I suppose, but in relation to the spouse, first of all, they have an entitlement to a legal right share. So they will probably opt to take the legal right share. So he'll end up having to give 1/3 of his estate to his spouse, okay, because they have that entitlement under the law. So you can leave everything to charity, but only a certain amount of it will go to charity after the spouse's legal right share has been discharged, paid. What about his children? He can leave nothing to them in the will, but they can make what's known as a Section 117 application. Okay, so the child would, in that situation, would have to prove that the testator failed in their moral duty to make proper provision for them by will or otherwise. And if the court was satisfied that they hadn't, well, then the court would make an order in favour of the children, and that could cost the estate a lot of money as well. Okay, so typically, you know, a solicitor giving advice to Jim would be, you know, outlining that Section 117 applications could be brought, and the whole estate could dwindle away to nothing with the cost of litigation. So it's probably best to leave your children something, or at least a very detailed note with your solicitor as to why you're not leaving them any property. So that's all I was going to outline today.